Let me grab all those out of your way. Oh, you need the mic. Sorry.
I don't need it. He went through a lot of witnesses and talked about a lot of the witnesses. He got to Detective Casey Young. He didn't talk about him very much and whether or not his testimony proved intent. He didn't talk about those internet searches much. I spent a lot of time on my closing talking about how those internet searches showed us how Mr. Rasch's mind was working. His jury instructions. First-degree intentional homicide. While the law requires that the defendant acted with intent to kill, it does not require the intent existed for any particular length of time before the act is committed. It need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if at all, from the defendant's acts, words, statements, if any, and from all the facts and circumstances in this case bearing upon intent. That one, defendant's acts, words, and statements. We have a lot of acts, we have a lot of words, and we have a lot of statements. When you retire back to the jury room, look at all of those things, both before, premeditation, and after. Consciousness of guilt. That is one of the jury instructions that you will read about concealment, and that can be consciousness of guilt. When you conceal a crime, that you as jurors can decide is consciousness of guilt. When you immediately text your son and daughter, "Where's Crystal?" Consciousness of guilt. Those things can be used as circumstantial evidence by you to determine intent. Detective Casey Young. I think it testified for an entire morning. That entire testimony was intent. And you ask, why did he leave the gun out? Because he cleaned it. He purchased a cleaning kit. When he bought the gun, he cleaned the gun. Even his version of events don't make sense because there was no blood on the gun. He cleaned the gun. That was his new toy. He was so proud of that gun. He was so proud of that CCW class. He immediately messaged his daughter about it. That's why he kept it, and he thought he could get away with it. He wasn't going to destroy it because he thought he cleaned all the evidence off of it. Remember, how long do fingerprints last on plastic? He cleaned that gun. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. I don't have to prove motive, but I think we have motive. Divorce, money. Crystal had over $8,000 in her account. He drained it. He drained it down in a matter of 2 weeks. You are not to search for doubt. You are to search for the truth. You are the judges of credibility. What does that mean? Let's go to that jury instruction. You will get these, but really, some of the highlights of credibility. Believability. It's the clearness or lack of clearness of the witness's recollections, the reasonableness of the witness's testimony, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend to either support or discredit the testimony. Like, for example, lots of other previous lies that have been told to law enforcement throughout the entire course of the investigation. There were a bunch of questions up on that screen that the defense said were left unanswered. Remember, closing argument is not evidence. But those questions, number one, you saw the binders and boxes and stacks of evidence. You saw them talking to the social worker about the defendant's the victim's mental health counseling and her medications. We looked into her mental health and her medication. There is absolutely no evidence in this case that her failure to take those medications would result in her committing suicide. No evidence, no testimony, nothing. And then the question is, why did he shoot her in the car? I don't think he wanted to shoot her in the car. She would not get out of that car. She wanted to go back to that church. That is why she was shot in the car. He was going to shoot her at the residence, so he had time to get rid of the body, but he did not want to shoot her in the car, and she would not get out. The defense keeps telling you over and over again, she wanted to switch attorneys, she wanted to switch attorneys, she wanted to switch attorneys. The only evidence in this case that she wanted to switch attorneys is the defendant's own testimony. You give that testimony the weight of evidence that you believe it deserves, given all of the information you've learned throughout the course of this trial. They talked about, the state, they presented all this extra stuff that they didn't need to present. There's nothing about intent that the state presented. First of all, this is a homicide trial. It is important that you as jurors understand the entire investigation that law enforcement did. There was over 400 exhibits in this case. You needed to understand the investigation from start to finish. Because remember, during this defendant's statement, I don't know where Crystal is. I don't know what happened to her. So at the point where we get the Mitsubishi, we have to prove that's the crime scene. So that's why we tested it, all the blood in the Mitsubishi. That's our crime scene. We have to prove that he had her in that vehicle. They were in that vehicle together. That's why we tested that vape, to prove that the two of them were together. And then we tested the portions of the gun that we thought were most likely to have blood. The initial test, no blood, no DNA, so we tested the holster. These are all things that law enforcement went through to prove this case. We did not have some sort of laser focus on the defendant. People said Crystal was missing. We saw that video with Kukan where he's walking from the smoke, closing down that vehicle, and then that vehicle heads to Adams County. Then he's buying sulfuric acid. In the business, we call that clues. Okay? We know that sulfuric acid can damage a body. And so the immediate thing that law enforcement thought was, he's trying to get rid of her body. We got to get there to try to find what evidence might be left in this case. Then we searched for 3 days and didn't find any bones. And then finally found bones and had to build a case from there. All the while, the defendant was maintaining, I don't know where she is. 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 10 hours. Never said she shot herself. They say, we'd still be in the same spot. We don't know because he never said that. He never once said that until the mountain, the iceberg of evidence came down upon him. Then he gets on the stand. She pulled the gun out and put it to her head and shot herself, but the gun didn't have any blood on it. Remember also her mom's statement about how Crystal felt about firearms. When they tried to take her shooting, she put her hand over her ears. Is it reasonable that that same person that had that attitude then just pulls a firearm out of the center console and just, without a word, puts it to her head and shoots herself? Again, I'm not going to go through all this testimony, but they say, we go through all these steps. We prove where his vehicle is. We prove where his phone is. We prove that he's the one that's using his phone. We prove the transactions happen, but we have to prove that he is actually the one committing all of those transactions. We prove that the two of them were together. The data for the weeks prior all existed. Defense had that data. Defense had that data. Now they want to stand up here and say, we didn't see those maps. We don't know what was happening. They had it. They had all of that information. It wasn't some mystery, but now they want to get up in closing and they smoke and mirrors because there's a mountain of evidence against the defendant and say, well, the state didn't do this. The state didn't do that. The state didn't do this. Do not search for doubt. You're supposed to search for the truth. Look at all of the evidence. You decide the truth. Then they say, I can't remember the word they used, but the defendant's not very cunning or sophisticated or something like that. Well, he's sophisticated enough to almost immediately upon Deputy Kukan leaving, Google's search warrant, Fourth Amendment, finds the statue, looks at the statue. That is pretty sophisticated. I mean, he's not a lawyer. That is pretty sophisticated. I mean, look at all of those searches, but that one in particular shows how calculated and cunning he is. Ladies and gentlemen, don't believe the deceit. Destruction of evidence, consciousness of guilt. Detective Young's testimony, 3 hours, 4 hours, proof of intent. Please retire to the jury room and return verdicts of guilty on both counts. Thank you.
Counsel approach. All right, ladies and gentlemen, I used to hold this up to my head because that would be like those of you who are old would remember Johnny Carson and Karnak, but I don't do that anymore. All right. Anyway, this is the 4 jurors who are going to be excused. I will ask: is there anybody who doesn't feel well enough to go forward and see this matter through to deliberations? Nobody's raised their hand. All right. All right. The jurors who will be excused are juror number 4, juror number 7, juror number 22, and juror number 45. Now, members of the jury, the duties of the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. The following 4 verdict forms will be submitted to you concerning the charges against the defendant, Zachariah Rasch. 1 reading, we, the jury, find the defendant, Zachariah Rasch, guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we, the jury, find the defendant, Zachariah Rasch, not guilty of first-degree intentional homicide. Another reading, we, the jury, find the defendant, Zachariah Rasch, guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Zachariah Rasch, not guilty of mutilating a corpse. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each of the counts in the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. That person's vote is entitled to no greater weight than the vote of any other juror. When you have agreed upon your verdicts, have them signed and dated by the person that you have selected to preside. If I could have the bailiffs approach, please. If you could swear the bailiffs.
Do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in some private and convenient place, subject to the direction of the court until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon? So help you God?
Ladies and gentlemen of the jury, it is now time for you to deliberate. You can discuss the case. That needs to come off. All right, we did have one sidebar during that session. During that sidebar, I simply asked the council approach and simply asked if there was any concerns about any of the jurors. You obviously had the opportunity to watch them during the course, and sometimes concerns are brought to the attention of the court, and rather than excuse somebody and then have somebody say to me, well, geez, I for one reason or another, I thought that juror should have been eliminated. I asked you to approach. Both indicated they did not have any problems with any of the jurors, and the 4 alternates were released.
That's correct, Your Honor. I just, out of curiosity, how were the 4 alternates selected? Was it random?
Random. Like everything else in our life, the computer randomly generates 4 alternates. You can see the sheet if you like.
No, that's fine. I just
I
didn't know if you had a 16-sided die up there or something.
And if you want me to explain how a computer handles things, you are completely in the wrong place.
Understood.
So, all right, folks, I would ask that you remain in close proximity to the court. If you do leave, please make sure the bailiffs have your phone numbers. All right, we stand adjourned.